Good afternoon, everyone, and welcome to the third in our webinar series on the changes introduced into UK law by the Data Use and Access Act 2025. Bit of a mouthful, so I will call it DUAA. My name is Renzo Marchini, and I'm a partner in the data team in London. Thank you so much for rejoining us, those of you that saw the first two episodes, and joining us for those of you coming late to the party. Regular listeners will know that we're giving an overview of key changes to DUA as they apply to data protection law, and we're not dealing with other aspects of the DUA, such as provisions of smart data and changes to the law on registers of births and deaths. Today, I'm joined by Camille Ebden, a director in our team, and time-honoured fashion, I will let her do most of the talking. We will finish within 30 minutes, that is at 4:30 p.m. in London time, and we're speaking for around 20 minutes, allowing good 10 minutes for questions. Please do ask us questions using the Q&A function on your screen, not the chat function, the Q&A function, please. I'll moderate and may take them as we go along, if convenient, or I'll take them at the end. And if we do run out of time, then you haven't wasted your typing. We will respond to questions posed in writing. We'll send you a copy of our slides and a link to a recording, which will also be posted on our YouTube channel. And do subscribe to that if you have not already. Next slide, please, Rachel. So just an overview of the series. Episode 1, we covered overview and changes to Article 6.1 of UK GDPR, legitimate interests. A recording is available, as I mentioned, on our YouTube channel, and forgive my typo there. Data subject rights, complaints, automated decision making and children's data was the subject matter of last week's episode, also on our YouTube channel. Today, cookies, marketing rules and purpose limitation, and Camille will give a further overview in a moment. And next one, last one, in 2 weeks' time, will be the discussion on data transfers, research changes, and the ICO's role. Thanks, Rachel. The next slide now, please. A very quick recap on what we've covered so far. In episode 1, we talked about the timeline of the changes. Camille is going to delve a bit more deeply into that in terms of the changes we described today, but the overview is all the data protection changes will be in effect by 19th June 2026. Some are already in effect, those in relation to DSARs, for example. Legitimate interests, we talked about a new recognized legitimate interest introduced into Article 6.1. For example, you don't have to do a balancing test if you're disclosing or processing data for public task requests or for safeguarding purposes. We also talked about examples now enshrined in law, only examples though, of what should be or could be considered a standard legitimate interest under the existing Article 6.1f, pertinent to today's topic, direct marketing. In episode 2, we talked about changes to the DSAR requests, a statutory footing for what was previously ICO guidance in terms of the scope of searches that need to be carried out in relation to DSARs, reasonable and proportionate searches only, and the so-called stop the clock provisions. We talked about the need for controllers to have in place a complaints procedure, not only in relation to DSARs, but in relation to data processing generally. And lastly, we talked about greater flexibility for automated decision making. The existing controls, as they are at the moment in UK GDPR, apply if you use sensitive personal data, but if you don't, then there is more flexibility. And now I'll hand over to Camille as we go on to the next slide, please, Rachel.
Thanks very much, Renzo, and hello, everyone. So in today's webinar, we're going to cover changes to PECR fines and PECR enforcement. We're also going to look at changes to the cookie rules under PECR, including some new exemptions from the requirement to have consent. We're also going to be looking at changes to direct marketing. And lastly, we're going to be looking at changes to purpose limitation rules. So we're going to be looking at purposes that can now be considered as compatible with the original purpose. We'll then go through some takeaway actions, some practical takeaways, before turning to any questions that you have. So next slide, please, Rachel. Thanks very much. So the first topic then are the changes that DUAA makes to the UK's privacy and electronic communication regulations, known as PECR. Now, until now, the maximum fine under PECR has been just 500,000. But DUAA is in the process of changing this to align the maximum fine under PECR with those that we already have under UK GDPR. So this will mean a maximum fine of 17.5 million or 4% of global annual turnover, whichever is higher. Now, this maximum penalty can be used by the ICO for breaches of PECR regulations, such as the cookie consent rules, restrictions on the processing of location data, and also various direct marketing provisions, including the rules for direct marketing by electronic mail. Now, DUAA has also made some other amendments to the ICO's enforcement powers under PECR, again to align them with UK GDPR. So it removes the requirement for the ICO to establish that a contravention has caused substantial damage and distress. And it also gives the ICO new powers under PECR, such as the power to compel a witness and the power to commission technical reports. Now, in terms of timing, these changes are due to come into force as part of stage 3 of DUAA's implementation. So approximately 6 months after royal assent, which means that we're looking at around December this year. So we'll move on to the next slide now, please. Thanks very much. So moving on to the changes to the cookie rules under PECR. Now, currently, under Regulation 6 of PECR, consent is required for the storage of or access to information within end-user devices via cookies or other similar technologies, unless the current 2 exemptions apply. Now, before I turn to what those current 2 exemptions are, I just wanted to flag a change that DUAA has made to the rules about obtaining consent. So the updates to PECR set out that where the same person is storing or accessing information in the terminal equipment of a subscriber or user for the same purpose and on more than one occasion, you only have to provide transparency information and obtain consent from the user or subscriber in respect of the initial use, so that initial storage or access. Now, before you get too excited, looking at the ICO's draft revised cookie guidance, and just to let you know, they have made draft changes to their cookie guidance for these DUAA changes, but we're still awaiting a final version. In their draft revised guidance...
Sorry, Camille, Rachel, I think you've gone back a slide by mistake.
No, I think that's the right one.
I can see an old slide. I don't know why. Did I press something? Do people individually? Oh, forgive me. Did I carry on? So sorry.
No problem, Renzo. So I was talking about this change to PECR, where it says that if you are storing or accessing the terminal equipment of the user for the same purpose on more than one occasion, you only have to provide transparency information and obtain consent from the user in respect of that initial storage or access. However, the ICO's draft revised cookie guidance sets out that you only need to consider how long, that you still need to consider how long consent can be valid for. And they recommend that in general, that you request fresh consent for cookie type technology every 6 months. But they sort of set out different factors to consider that will sort of affect how long a period before you seek refreshing consent might be in particular cases. So I wouldn't sort of think that you only have to get consent once and then, that's it forever. And it will be worth keeping an eye on the ICO's guidance when they issue their finalized version and see if there are any updates on that. Okay, but so we're going to stay on the same slide, but turning to the current exemptions from the consent requirement. So the two current exemptions where you don't need consent to store or access information on an end user device. So the first one is where the storage or access is necessary for the sole purpose of carrying out the transmission of a communication over an electronic communication network. Secondly, where the storage or access is strictly necessary to provide an online service requested by the subscriber or user. Now, helpfully, the DUAA changes to PECR have added into PECR itself examples of when storage or access will be considered strictly necessary to provide the service requested by the subscriber or user. And to give you a flavor, these include preventing or detecting fraud in connection with providing the requested service, and also to prevent or detect technical faults in connection with the requested service. So it is well worth having a look at that list for clarity on what counts as strictly necessary to provide an online service requested by the subscriber or user. But turning now to the new exemptions, still on the same slide. So there are 3 new exemptions where you do not need to have consent to access or store information on end user devices. So we've got a statistical purposes exemption, a website appearance exemption, and an emergency assistance exemption. And if we could turn to the next slide, I will take us through the first of those. Thank you very much. So the new statistical purposes exemption, for this to apply so that you don't need to have consent, you have to be providing an online service. The sole purpose of the storage or access must be to collect information for statistical purposes about how the service or the website that provides the service is used with a view to making improvements to the service or website. Any information that you collect via that storage or access must not be shared with any other person, except if you're sharing it because they are simply going to assist you with making improvements to the service or website. Now, the subscriber or user, as ever, must be provided with clear and comprehensive information about the purpose of the storage or access. And they also have to be given a simple and free means of objecting. So if somebody doesn't consent, but they also opt out, then you wouldn't be able to continue to rely on this exemption. The exemption sets out that you only need to present the storage and access transparency information and provide an opt-out once where the storage or access will be used by you for the same purpose. Now, the ICO's draft revised cookie guidance states that statistical purposes should be interpreted under the definition that exists in UK GDPR. And in short, this means that you have to aggregate the information that you collect, and you shouldn't store any personal data for any longer than is necessary for your aggregation purpose. The ICO further state that if you make inferences or take decisions about people or categories of people based on information like their IP address or their category in your service, or also if you retain individual level information after aggregating it, in those sorts of situations, you will not fall into the exemption and you will need consent. So they've set out in quite a lot of detail in their draft revised guidance exactly how the new exemption will apply. So I do recommend taking a look and keeping an eye out for the final version of the guidance. If we could turn to the next slide, please. Thank you. So the website appearance exemption. Now, for this to apply so that you don't have to have consent, you have to be providing an online service by means of a website. The sole purpose of your storage or access should be to enable the way the website appears or functions to adapt to the preferences of the subscriber or user, or to otherwise enable an enhancement of the appearance or functionality of the website. Now, the subscriber or user must be again provided with clear and comprehensive information, and they again have to be given a simple means free of charge of objecting, so an opt-out. Again, the exemption sets out that you only need to present the transparency information and provide the opt-out once where the storage or access will be used by you for the same purpose. Now, the ICO's draft revised cookie guidance sets out that this exemption is not about adapting the content to display to a user on your service based on known or inferred interests or behaviors about them. So, for example, if you want to use a user's profile or their previous browsing history to decide what content to promote at the top of a web page or to choose which advert to serve, the ICO is clear that this is not going to fall within the exemption and you would need to obtain consent. And if we turn again to the next slide, please. Thank you. So the third new exemption is the emergency assistance exemption. So this sets out that you can store or access information in an end user device if you receive a communication from the end user device, which is a request from the subscriber or user for emergency assistance, or otherwise indicates that individual is in need of emergency assistance. And the sole purpose of your storage or access is to ascertain the geographical position of the subscriber or user with a view to the emergency assistance being provided. Now, in terms of what this means in practice, the ICO's draft guidance says this could be used, for example, where a user has pre-enabled a motor vehicle e-call functionality that will automatically contact emergency services in certain situations. I assume where it sort of detects that the car has suffered a kind of terrible accident, or also where a user presses an emergency button on a personal safety alarm. Okay, so we'll move now on to direct marketing.
I have a question,
Oh, yeah.
Camille, which is, are there any changes to the rules which allow cookies to be used to prevent fraud?
Are there any changes that prevent cookies
That
being...
permit cookies to be used to prevent fraud? But if you, shall I just quickly take that one? Actually,
Yeah, sure.
I hope there is a change, which is what Camille hasn't mentioned, because you can't cover absolutely every single detail. The existing exemption of storage or access being necessary provision of information service remains, but the statute now gives examples of what that means. And one of the examples, and I've had a chance to just quickly look it up to get exact words, is something is considered to be strictly necessary for an information society service requested by the subscriber or user if it's to prevent or detect fraud in connection with the service provided, which of course is a view that people have long taken anyway, but it's nice to see it in statute. And Camille, I'll hand back to you. Also, one last thing, someone has put their virtual hand up as an attendee. We can't let people speak, so sorry. So if you've got a question, please put it in the Q&A box. Thank you, Camille.
No problem. Thanks very much, Renzo. Right, so direct marketing. So DUAA has inserted a definition of direct marketing into the UK GDPR to align with the Data Protection Act 2018. Now that definition is just the same as the one that's in the Data Protection Act 2018, so I won't take you through it, but it's just a flag that it has been added. Now, as Renzo mentioned at the beginning of this session, DUAA has also added some examples of processing that may be necessary for a legitimate interest. And one of these examples is direct marketing. Now, these examples were taken from the recitals of the UK GDPR. So effectively, DUAA is making what was already in the UK GDPR recitals as sort of interpretive guidance now legally binding, or once it comes into force, legally binding. However, this does not mean that legitimate interests will always be the relevant legal basis for direct marketing. You still need to consider PECR. And if your direct marketing requires consent under PECR, then you will need to rely on consent under the UK GDPR for your direct marketing. So for example, if you are carrying out direct marketing by email and you cannot satisfy the soft opt-in requirements, then you would need consent from recipients to send that marketing, and you wouldn't be able to just rely on legitimate interests. So something to be aware of with that change. Now, another direct marketing change is the soft opt-in has been added for charities. So DUAA has updated PECR so that the soft opt-in rule, which has already been available for businesses to use regarding electronic marketing, if they meet the criteria, is now going to be available for charities. Now, in particular, this means that charities will be able to send electronic mail direct marketing aimed at furthering their charitable purposes to individual subscribers as long as the charity obtained the email address when the person offered support or expressed an interest in the charity and its charitable purposes. As long as they gave the person the opportunity to opt out of the charity using their details in this way when it first collected them, and as long as it gives the person the same opt-out opportunity each time they contact them. So worth bearing in mind if you are a charity. Now, the timeline for these changes to come in force, again, they're expected to come into force around December. And I'm not sure if I actually said regarding the PECR cookie changes, but those are also expected to come into force around December. So moving now to the purpose limitation changes on the next slide. Thanks very much. So DUAA has inserted a new annex into UK GDPR, and this has a list of purposes that can be treated as compatible with the purpose for which the controller originally collected the personal data, but only if it's not reasonable to get consent for that new use. Now, the list of compatible uses includes responding to a request for information from a public body in certain circumstances, disclosures for purposes of archiving in the public interest, using personal information to protect public security, using personal information to respond to an emergency, using personal information to detect, investigate, or prevent crime, also for the protection of vital interests of data subjects and others, and for safeguarding vulnerable individuals, as well as other purposes. So it's well worth having a look at that list in full, where these types of reuse purposes may be relevant for your organization. And again, the timeline for these amendments to enter into force is expected to be approximately December this year. So if we turn now to the takeaway actions, and what does this actually mean for what you need to do? Well, firstly, it's well worth using this as an opportunity to revisit your cookie compliance. And if you make any changes to when you rely on consent, then you'll need to update your consent management platform, and you'll need to update your cookie and potentially privacy notices as well as needed. Secondly, it's worth checking your legal basis for direct marketing is appropriate under PECR and GDPR. If you don't need to rely on consent under PECR and you want to rely on legitimate interests, then you should look at carrying out a legitimate interest assessment, an LIA. If you are a charity, then it would be well worth exploring whether you can rely on the soft opt-in in future for electronic mail direct marketing. So that's direct marketing by email and SMS, for example. It's also a good opportunity to review your approach to purpose limitation. Will you be able to reuse data more widely than you thought? So those are the key takeaway actions that we would suggest. And I think, Renzo, we can turn back to questions.
Yes, one more at the moment, but let's see, please, anyone, if you've got questions, please put it in the Q&A function. Someone says that they thought they read that there was a change to the consent rule for cookies, and you can actually grab consent by browser settings. You didn't mention it, is that right?
So it's a good point to raise. So the DUAA changes to PECR do refer to the means by which a subscriber or a user can signify their consent, can include amending or setting controls on the browser. But they do sort of set out that it's just one way that user consent can be signified. And actually, if you look at the ICO's draft revised cookie guidance, they make it very clear that under kind of current technologies and systems, you can't assume that each visitor to your online service has either configured their browser settings regarding cookies or that they use a browser with these protection features. So the ICO says for now, you mustn't rely solely on browser settings to indicate consent. So unfortunately, I don't think this latest change to PECR means that we can all say goodbye to cookie banners, at least not yet.
Thank you. And I'll just add to that, Camille, of course, is exactly the same in the EU. The directive which brought in the consent requirement, which was the 2009 statute that amended the original 2002 e-privacy directive, had that in a recital, similar language, that consent may be capable of being grabbed by browser settings. And of course, the regulators in EU as well have always said that it doesn't actually work. A question on, let me read it out aloud and see one of us can answer it. I hope we can. Does the expanded limitation to cover detection, investigation and prevention of crime still require a judicial warrant, or does it anticipate a request from law enforcement would be sufficient?
Oh, it's a good question. So does the expanded limitation to cover detection, investigation and prevention of crime?
So that's the purpose limitation point, isn't it?
Yeah. Does it still require a judicial warrant, or does it anticipate a request from law enforcement would be sufficient?
Well, shall I have a stab at that, Camille? I
Yeah,
think I don't think the statute goes there. Is the answer, in that it just gives an examples of what is going to be considered a compatible purpose under the purpose limitation provision. But even if there was no example, whenever you've got a compatible purpose, you're still got to ask yourself whether or not you have a legal basis, and whether or not you have a legal basis might depend under Article 6.1, will depend on whether or not there's a statutory obligation to reply to something. For example, if there's an evidence request under a statute, properly cited, going through the proper procedure, or it's simply, actually, we'd like this information, it would help. And in those circumstances, you'd have to look at legitimate interest. So I hope, question answerer, asker, that gets to the point that you're getting at. Okay, one last question, a bit long. Let's see if I can read it out quickly. ICO's Mythbusters state, where PECR requires you to get consent for the use of storage and access technologies, you can't then flip to using legitimate interest for subsequent processing. For compatible purposes, how would this work? Will it always have to be reliant upon consent? Camille? Got a view on that
Mm.
one?
So when we're talking about PECR and storage or access, if you're required to get consent, then I think, the ICO's view is that you're going to, I think they sort of expect that
Yep.
you're still going to need consent for the subsequent processing.
Yeah.
Um,
Yeah, I think that's right. And I think as I just mentioned, original purpose limitation, if you do go beyond the original purpose, you're still going to ask yourself, what is my legal basis? And I think I would support that, Camille, that the EU has also said, if you need a consent for cookie and the subsequent processing of personal data, then that also needs to be based on consent and not on legitimate interest or performance of a contract or whatever else. And I'm rushing there and cut you short, Camille. Forgive me, because I promised people we'd finish by 4:30 and we've gone a minute over. So I want to thank everyone for joining. We trust, like previous episodes, it was helpful, gives you some of the answers. We'll send you slides and a recording very soon. And we do hope you can join us 2 weeks today, 23rd of October, same time, for our coverage of changes in relation to data transfers, research changes, and the ICO's role. Thank you very much, everyone.